Hello, everybody. This is TJ. We're going to get started with our membership meeting for today, which is, what is it now? May 13th. Wow. The year is flying. Well, thank you for all for being here. We're going to get right into our session today. I actually have a guest who's also going to be on today, who's going to help me with some of the teaching. You may be helping with some of what we do down the road. So, again, thanks everybody for being here. As you know, I'd like to start each call with a prayer, just for a good blessing, for protection over those who are on here. So if you're free feel free to join us if you want to, or don't if you don't want to, that's fine too. In the name of the Father, Son, and the Holy Ghost. Thank you, Lord, for all the blessings you've given and the opportunities to come together. We know where two or more are gathered. We know that you're there with us. So we thank you for that. We ask for your blessings over the words and the thoughts and the ideas shared today. And let those things be a blessing to those who can learn and grow from the experience of being part of what we're doing here at urlaw.org. Okay, amen. So, the other thing I want to just always mention at the beginning of every meeting is we are not in the business of giving legal advice. We are not attorneys, a bar attorney, that sort of thing. We believe in free speech, though, because you have a right under the First Amendment to talk about these things, no matter what anybody tells you. And that kind of gets into the whole subject matter of tonight, which is jurisdiction. We're going to talk a little bit about what that means, how it might affect what you're doing. There are many circumstances where you assume the jurisdiction, that is the authority over you, exists when it doesn't, until you volunteer. And sometimes we volunteer without realizing we did it, just by answering our name. And so we're going to talk a little bit about that tonight in our discussion. But before we get started, I do want to make sure that we get a few admin things out of the way. Just keeping in mind that, as we say, we're not giving legal or tax advice. We do teach on these subjects. It's certainly something we have a free right to do. But you make your own decisions. That's why UR Law is branded as it is. URlaw.org. That means you are responsible for your own actions and what you do and say. We just try to give you direction and ideas to help you, do a better job with those things in your life. Um, but today's subject will be jurisdiction is everything plus Q&A. And the Q&A will primarily be focused on those who are in our advanced training for the tax and trust combo package or the delete debt training. We go with those questions first, all right? Just a reminder, if you have account payment issues, you're dealing with how to log in, or maybe your login's not working, or your payment is a problem, that is all support handles. They do not answer questions about class content. There are other ways to get that done, and once you're inside our membership area, there's instructions on how to ask questions. But asking questions of me or about a class or a subject is not the same as asking about how to log in or something like that, or if your account status is correct, whatever. So for that, you go to our support page. Do not email. Send a support ticket at urlaw.org/support. Okay, use that link, because what that does is gives us both a record of what you requested. So there's a record because emails get lost, they get bounced around, we don't see them all. Sometimes people send emails without any information, not enough information to do anything with. The support ticket tends to push you in a better direction. Plus, it gives us information on you so we can look up your account status and what's going on. Okay. Um, if you want to learn about upgrading different courses, different packages we have, go to urlaw.org/join. It's pretty obvious on the webpage if you go to the top of the tabs where that is. I mean, if you just go here to join and upgrade, and you'll see how to do that, okay? Um, if you're currently a premium member, because just about everybody that's a paid member is at least a premium member or above, the main premium member page is where we post these meeting announcements, where we have a lot of our general content. The shortcut to that is urlaw.org/PM. If you're curious about our delete debt course, zero tax course, trust course, which until you looked at it and really studied it and asked a few questions, you might not realize just how valuable it is. But those are found on our join page, so /join. I can tell you, if you do the math on what you might be confronted with in terms of potentially losing everything to a lawsuit or an accident, or who knows what kinds of things can happen, if you plan ahead, you can prevent a lot from happening. Okay, so It's all about planning. It is not about fixing everything that's broken because sometimes if you start too late, our philosophy is it's hard to buy the insurance after the fire, and even we can't turn back time. So planning, preparation, and doing things right from the beginning will give you the greatest odds. It's people that go back and try to fix something broken that makes it much more difficult. So keep in mind, these things are meant to be preventative. Now, the delete debt one could deal with current debt situations, of course. If you're dealing with a no victim criminal case, really no harm party, kind of basically innocent, like I had an example of somebody who was accused of something and there was no evidence of it. It's a relatively minor thing, but they're turning this thing into a felony. Well, it's going to be easy to get rid of that with the right approach, with the right focus. You do not want to step into the jurisdiction the way they want you to, but you certainly need to have a plan of action how to deal with that. And if you wait till it's too late, it's hard to turn back the clock. Even we can't do that. If you have a general want to have a general study on how to win in court, that's a separate course. It's a third-party course that we just endorse. It's urlaw.org/JD. Recommend that alongside with our premium membership. It's not included with the premium membership. Um, if you're looking for business capital, we have some other sources, VCAP Global, and Capital Finance. If you get a small business looking for funding, we help with that as well. We're big believers in helping entrepreneurs. I also manage a hedge fund. I helped found one. And with that area, we help investors who want to invest in helping small businesses bring capital and get a real nice rate of return on their money for doing that. Little as in general, we pay about 10.5% interest on the use of those funds. So if you're an accredited investor, that means you got a pretty good net worth. You don't have to be wealthy, but just but not the very bottom. You can look into those options using our website for our venture capital fund. Okay, reminder, if you need to communicate with us, again, email isn't a bad thing, but if it has to do with your account and logins, you have to use a support ticket on that page. Go to that page, submit the ticket, don't email. If you just want to ask comments, well, there's a comments section on each training page, depending on what level you're at. Or we have a Telegram group. So if you're not part of Telegram, you need to be. That's just one of the ways we communicate. And you'll want to make sure you post your questions there. If you go there, you'll see the dialogue that I have with different students at different levels. Even if you're not in the class, you can look at the dialogue and see what's going on. Of course, if you don't follow it and you want the content, then you need to go join and upgrade to one of those levels. A lot of people go in and on the premium page and don't really take the time to look around. There's a lot of content there. It's more like a library than a course, but it has 6 or so different courses you can go into that are right there on the premium member page, as well as downloads, which have a ton of more information. In fact, we'll actually cover a couple of those download documents today on jurisdiction. That's already right there in your folders if you're a premium member. Okay? And again, next level training, such as deleting debt or why would you want to have a trust? Well, if you'd like to reduce your taxes, it pays for itself really, really quickly. So keep that in mind. All right, so now I'm hoping everything's good. I'm going to check the chats. There's no weird things going on. You can see my screen and all that kind of stuff. Hopefully that's working good for you. All right. So now we won't be taking questions until a little bit later. I'll be taking questions from specific people. I see Daniel Garcia way there. How you doing, Daniel? Looking good as usual. And if you're not familiar with him, you're about to meet him in a few minutes. But we're going to talk about I think it's maybe the most relevant discussion in learning the basics of law. And that is, what is jurisdiction? I've pulled up a couple of documents. These documents are, yeah, again, if you're a premium member, you already have access to this. But this document overview, let me see, I think I got this in just to double check this. Yeah, it's in the general downloads on the premium member page. But what is jurisdiction? Jurisdiction could be a geographic area over which authority exists, legal authority, or the authority to hear and determine causes of action. Now, let me give an example. If you're in the state of Oregon, you commit a crime in the state of Oregon, this Oregon has jurisdiction, that territory, okay, over what happens in its area. But certain courts have certain types of jurisdiction, such as um, child support or traffic. Those are different jurisdictional courts. Which, by the way, we're going to probably talk to you here in a few minutes to help you find out that those courts generally, if you know what you're doing, actually don't have jurisdiction, but they do have their area, their subject matter. That's called subject matter jurisdiction. The other part of this problem becomes when they get personam jurisdiction. See, which I ask this question often, what's more important, personam jurisdiction or subject matter jurisdiction? And the answer is both, because if a court does not have both, they cannot proceed against that individual. What you don't might not realize yet is that most of them don't have jurisdiction over you, the person, if you know who you are and you present yourself the right way. Again, we'll probably have a discussion about this here in a minute. But you're only assuming that you're in their geographic area. But the key is in the definitions. What is a geographic area? For example, in the IRS code, the District of Columbia is the United States and nothing else, except the territories that they own, such as Guam, Puerto Rico, and so forth. But it's not the 50 states. Wait a minute, I've lived in the United States my whole life. That's a different definition of the United States. IRS code says for the purposes of this chapter, the United States is the District of Columbia, Guam, Puerto Rico, etc. So there's an example where if you read the actual statute, it doesn't apply everywhere. That's why learning how to kind of look for these things in the law can help you in dealing with these matters. Now, does that say just because you heard that from me that you can just stop paying your taxes? Didn't say that. I said, know what the law says and act accordingly in your own conscience and what that means. Okay. So that's just a quick example. But I'd like to, hang on, let me get Daniel up here. You want to raise your hand and I'll unmute you there, Daniel. I see you there, so I can do it probably. And we
Hey,
hear you okay?
good, good. Can you hear me?
I can. Thank you, sir.
Roger that.
Now,
Um,
Daniel's been a long time friend of ours. He's just been a student of ours and many other subject areas. He's done many things. And he has a very unique approach to how he does things. And it is our plan going forward that you're going to hear a little bit more from him and some of the things that we're going to be doing. And so I think after you hear him for a few minutes, you're going to see why we want to make him part of the team. And Mark, if you want to turn your camera off, that's fine. We're just watching you walk around, do stuff. It's kind of distracting, if you don't mind. Go ahead, turn your camera off so we don't have anybody distracted. Um, there you go. No, not quite. Anyway, watch you on your little Zoom thing. It tells you how to turn off your camera. There we go. All right. But if you do get called up, folks, when we do the Q&A, go ahead and you can turn your camera on then. We do like to see who's asking the questions. We have nothing to hide because honestly, they have nothing on us. So, sir, what would you say your experiences with using jurisdiction as an approach to dealing with legal matters?
well, I'm looking at the jurisdiction part of how things work. You take a look and you see that it's the authority that they have. So when I look at jurisdiction, I think of it this way. They have it. People say, oh, they don't have it. They do have it. I get a lot of arguments for that. Okay, fine. They have it. So somebody will tell me, oh, okay, no, they don't have jurisdiction. Okay, so why are you here? If they don't have jurisdiction, why are you arguing with them and why are you feeling so frustrated and why are you stuck? They do have jurisdiction. It's up to you
Yep.
to change it. You have to change it. So, and understanding jurisdiction, I came into a lot of things, started doing a lot of research. Like a lot of the people who are new at this many moons ago, I started looking into why they have jurisdiction. And I said to myself, I got angry. I just got mad and I kind of like was like this angry person, thinking that how can they do this to me, et cetera, et cetera. Okay, well, how can you defend yourself physically against these people who have jurisdiction? You can't. They have robots, thousands of them, that'll shoot you down for nothing, over nothing. So you have to say to yourself, and this is one of the things I learned at UR Law, is you got to live in equity. You got to try to be the kind of person that's going to say, you know what? Let me see what this is about. Let me see if they have knowledge. Of course, when you walk into a courtroom, you think that you know what you're doing. I swear I know what I was doing until
Like they saw it on TV and they actually know.
and they shut me down. Like I thought I could do in uh, Law and Order. I could just walk in there and say, "Well, you know what you're doing is fraud. Bailiff, arrest him." That's what they don't see in Law and Order. When they say, "Hey, bailiff, hold them in contempt, contumacious conduct, 30 days in jail." I was like, "Damn, 30." And then, I get this thing while you're locked up. They say, judge wants to see if you have changed some of your, ideas and thoughts. And that they actually came to me and they said that. And I was like, well, you know what? I don't know enough. I'm going to humble myself. I had to apologize. I had to get an attorney. I got out of jail. And I said, whoa, 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 whoa. This is not going to happen again. This can't happen again. I'm not going to let them have jurisdiction again, no matter what. So I started to understand. I started to focus on the three jurisdictions that are listed in Article 3, Section 2, Clause 1 of the Constitution: common law, equity, admiralty, and maritime. Admiralty and maritime are the same. Common law has a criminal ingredient to it. So does admiralty. But guess which jurisdiction doesn't have a criminal ingredient to it? Equity. So I said, wow, this is enlightening. So starting to learn a little bit more, I started researching and I found this one guy on the internet, this guy, TJ Mars. He was saying something about with exacting clarity, I explicitly do not understand the nature and cause of the actions in regards to the elements of personal joy. And I was like, whoa, this guy's smooth. He's like ice. He's like a bottle of champagne on ice. So I said, wow. And I just kept listening to it. So I kept listening to him. And I said, let me, at the time, I didn't really have much. So I said, you know what? I'm going to go find the money to join this place. And I started doing things. I started watching all the videos. I started listening. He started explaining on how you need to start, just go out there and live in equity. You see somebody with a woman with her hair done, give her a compliment. You see somebody with some shoes that look pretty cool, give them a compliment. You start giving that positive energy out, and then it comes back to you. I'm not trying to paint a pretty picture of myself or a pretty picture of the world because we know it's not all like that. But you can change what you do. You can change your decisions. And I started doing those things, giving people compliments, uh, you know, doing acts of kindness. I remember before, this one dude was burning, his back was burning. I live in Florida. He was really hurting. He needed a shirt. I had a white t-shirt, my favorite white t-shirt. Uh, I forget what the name of the t-shirt was, but they're very comfortable. And I was like, oh man, I had to take off my shirt and give it to him. I didn't like it, but I just did it. So having started to do those things, positive things started happening for me because I started doing good things without asking for anything in returns, without recording it, doing good things for people. I'm telling you, if you start doing these easy things, in order to receive, you have to give, but it doesn't necessarily have to give money. You could just give somebody a nice words. Your words have power. So I started to create my own jurisdiction, like a little jurisdiction of myself, doing positive things and, you know, giving people compliments and, you know, just doing something, anything good. If I could help, I would do it. Just be careful with who you do the nice things for. Just be careful. It's not for you to just go out there and start becoming I don't know if you ever seen the thing with Barack Obama going like this. He's got like a thing on, he's counting dollar bills. Don't be doing that.
People know what that means. Probably don't.
Don't do it that. Don't do that. What I'm trying to say is I created my own little jurisdiction in equity. You can do that. And then you start seeing things. The money for the class at ULR came out of nowhere. I can't even remember how it happened. It just showed up. And I said, okay, I'm going to put it into this and start learning and start looking at the things that I want to look at. If you want to follow me, you can go on Instagram. It's You Became the Money, spelled just the way it sounds. And then I started doing, now these positive things started happening for me, and I started seeing these things. I wasn't a big religious person, but then I started reading the scriptures that were in the UR law and other websites, but UR law really caught my attention with Matthew 5:25, Psalms 82:6, uh,
Hmm.
all those things. And I just started saying, wow, this started catching up to me. So I started becoming a person who spiritually changed his jurisdiction and became an equitable person, living in equity. So as I started studying things, just one thing turned into another. And then all the links on the chain came together. And now I just started moving. So
Mm,
when, when you understand
interesting.
when you understand jurisdiction, you understand they have it. Why? Today I did a video for my Instagram and Facebook. It was causes of action in creditor debtor law for the state of Florida. It's the same more or less all over the country, but creditor debtor law is what you need. You got to go over that. You got to see that. You got to see how that works. Who's the creditor and who's the debtor? You got to kind of get into that. I know a lot of you are already in that. A lot of the people that are already here are super educated because every time I've come in here, there's always been somebody that taught me something. I'm not here to do anything about teaching you something. I'm here to work together with you so that we can grow together. You see what I'm saying?
Yeah.
I'm not this guy that's going to come in here thinking that I'm teaching you everything. But I can tell you one thing. Every time, the first time I was taken advantage of in a courtroom, I said that was never going to happen again. And it never happened again. I went in there, I learned all of this, I understood. Why do they have jurisdiction? They don't have jurisdiction over the living soul, they have jurisdiction over the front. The third party put up in a transaction in name only. They
And
refer
that
to
name,
that.
by the way, they refer to you as a person. That's a legal term. It's not a living being. That is a legal term. It's a living entity. It's an entity that's not living. It's really an entity that's recorded on your birth certificate at the county record. It's just the name of a business.
That's it. So,
You're
I,
objectively a business.
yeah, and I did a video
And they
today.
have jurisdiction.
Yeah, they have it. People will argue with this me all the time. They got it. You, throughout your life, you became comfortable. Maybe back in the 20s or 30s, where the banks were doing wild stuff. Maybe that was necessary. Maybe a welfare program was necessary, but not today. The US dollar is the governing currency of the world. You can learn how to take whatever it is they call that US dollar, and before it gets liquidated into what referred to as cash, credit, you can take that credit and move it around in ways. There is immense ways, and you'll learn that here. You'll learn how to create 10 times multiples right out of thin air. I'm not afraid to share it with you. I'm not afraid to share it with you. You can turn yourself into a force of nature. I'm not kidding. Stop bullets, see in the dark, breathe underwater, and fly. The moment you think that you're less than that, you need to have a talk with somebody over here or with yourself. The biggest conversation you need to have is with that person in the mirror every morning. Look at yourself. Psalms 82:6. Ye are gods and children of the Most High. You are a God. You've been given God's status. Take advantage of it.
You're born into a royal family. Act like it. The royal family doesn't go into the court kissing the judge's butt. He might respect his court, but he understands who his authority is. You know, works like that.
There's people I would never in a million years. I go to other classes, like I go into other people ask me, hey, you know what? come over, show up, come to my page, this, and that. And I noticed that a lot of people. But when I came to UR Law, I saw that most people who are in this group, we're teaching each other here. There's no
Hmm.
one person teaching another,
I
everybody.
can give you a firsthand testimonial of that. I mean, people talk about I come on these calls and I tell these amazing things, but the reality is all I do is ask questions. The students who are out there in the field are the ones taking the theories and the ideas and implementing them. All I do is try to direct them, steer them a little bit, maybe in a better direction. But reality is, when I call this you are law, I was titled that with the intention that each of us have that energy. We are the controllers of our law and our legal situation. And a lot of people think, oh, I don't have a legal problem. Okay, so you don't drive a car, you weren't born, you weren't, you don't have birthdays, you don't go to public, you never went to a school, you've never been on a road, you never walked out your front door, you never went to a grocery store, you never did any business deals with anybody else. You've never signed a piece of paper for medical help. You've never done any of those things, but you say you don't live in a legal world. The reality is you all have not, I call it like the world problem, but you live in a world totally all about legalistic things all day long. Yet we run around thinking we don't need to know anything. And of course, the Bible says we perish for our lack of knowledge. It also says Jesus only had one category of people he didn't like very much, and those are the lawyers, right? He said, "Woe to you, lawyers, for you've taken away the keys of knowledge." In other words, they've set up a system where we're dependent upon them when we're not supposed to be that way. And therefore, we give up our power to someone else. Now, I don't want to put lawyers down. I know some very good ones. They're great for little business things, things like that. But the reality is, you're the one that's got to pick up the book and do the reading because it's right there. I mean, I've seen Daniel pull up books out of the law library, reads right out of it. The answer is right there. No lawyer's going to tell you that stuff. In fact, they will definitely not tell you some of the things that you can read right out of a law book because it takes away their power. See, woe to you, lawyers, for you've taken away the keys of knowledge. Well, let's stop doing that, right? You demonstrate it every day. Um, yeah, so there are other jurisdictional types of examples. For example, we go into traffic court. We think I got a driver's license, they have jurisdiction. Well, that's true. They have jurisdiction over the license holder, which is you're holding a document. And if you say that's me, you just accepted liability. You stepped into the jurisdiction that's there. It exists over that license holder. But what if, well, look, give me an example how you might handle it walking into traffic court in that situation. I know you got examples of that. Yeah, no, that was directed at you. I'm sorry.
Oh yeah, sorry about that. Yeah, I mean, you have to understand something. They they want you to argue with them. They want you to do all of
Yep.
these things. Now, I don't recommend doing this until you get real good and until you're not afraid to go to jail. I got to the point one day in my life where I said, I don't care if you lock me up. I don't care. And when they see it in your eyes, they know you want
They know.
they know you want to get back to your girlfriend with the nice little ooh la la. They know you want to get back to your kids. You got a job that you had to go to. I didn't care about any. I lost everything. I was homeless for 2.5 years. And I knew that if I was going to take these people on, I was going to have to be ready to go to lose it all. So I learned that part of what gave them jurisdiction is that birth certificate bond. Okay. In every case, a bond is evidence of a debt. So you got to understand that its holder is a creditor of the corporation, okay, and not part owner in as a shareholder. You got to understand the word bond sometimes is used more broadly to refer to also as unsecured debt instruments. So this goes really, really deep. So
Hmm.
got to understand that it's a bond supporting credit authorization. Okay. So where do I get that from? There's free information on the internet. I'm gonna give you a really cool book that you can go and read. It's free. It's called Creditors and Their Bonds. Now, do you want to use that process across the board? No. but this
Mhm.
thing will give you an idea of how the situation is being presented to you, creditors and their bonds. The first time I read that book, I was fascinated. Like I could not believe how much education it had. And there's no author to it. Anybody here can go and patent it. You can go and say it's yours and it's yours forever. And you can get paid from it. I'm giving you sauce. No one has patented it yet. I don't think. But I checked about 2 years ago, and you could go in and say it's yours, but it had to be somebody on the inside. Somebody on the inside. I want to say a judge, accountant, slash Walker Todd. That's another thing you want to read. The
Mhm.
affidavit of Walker Todd. Walker
Yep,
Todd
that's a good one.
was an attorney who worked for the Federal Reserve. So when I got approached by two, not district attorneys. There's two. I was at the courthouse. We just had won a case. I came outside and it was a foreclosure. What we did was is we drafted an instrument to discharge the debt. So me and my guy, he flew down from Texas and we got rid of it. And two high-level people from this courthouse in Fort Lauderdale found where I was down in the law library. I was walking out of the law library and they approached me. They were two, not district attorneys, they were two. I can't remember where they were, but they were from a high level office. So one of them came up to me and said, "Well, here's the sovereign citizen that we were looking for." And it scared me because I didn't know who they were. It was a one woman and one man. So I said to him, could you show me where the two words sovereign citizen exists in any law book anywhere listed together? I'd like for you to help me out with that. And he said, well, you seem to be the one that knows everything. Why don't you tell us? I said, well, we got into this little thing, this sword fighting thing.
Yep, they try to throw the burden of proof on you by asking those kind of questions, and you've got to flip it back on them.
Now, remember, they approached me with 10 sheriffs, 10 guys that don't know me, that would have arrested me on the spot, and they surrounded me. So I said to him, I asked him what showed me those two law books. And he said, well, I said, look, you have something against me, arrest me. If there's a crime here, arrest me right now. I'm not scared to go to jail. So I told him I was just like this.
So I
Said
love bologna sandwiches on white bread. Give it to me.
I told him to arrest me. To a, assistant attorney, no, not assistant job. I can't remember their titles, but they came downstairs and one of their family members worked in the felony clerk of the court. And she came out as well, and she knew me. And she knows that I was a really honest person, et cetera, et cetera. So, having said that, they came up to me and they started to try to intimidate me. So I just simply said, arrest me. You're going to wind up in civil litigation. I told them, I'll put a 42 USC 1983 civil rights violation on you so fast your head will spin. I've already beat you guys once. I'll beat you again. So what I did was is I kind of like moved my way between them and I went to the elevator and I hit the button and believe me, I wasn't fully confident. I was like, oh my God, this elevator. I was like, hurry up. Like I was elevator. 'Cause
Yeah, you still want to
I,
get out of there.
I didn't want to go to jail, but I stood on my square and I was ready to go to jail. I have people who have books, good friends of mine that have 3 or 4 books right by their door that are ready. When I get that call, when I make that call, I get my free call. They know to bring those books directly to me. Every time after the first time, I found a good friend, somebody that I could trust, who can go right to there, either mail these books to me or bring them to me. And I'll sit there. I don't bond out. I don't bond out. And trust me, I'm the kind of guy, I got everything waiting for me on the outside. All the goodies. So, but I sit there and I make the best of the time there. So
Mhm.
I like to shock the conscience. What that means is if you wait past 3 weeks and they're holding you, look that term up, shock the conscience test. So when you go past 3 weeks, now your lawsuit jumps from this much power to this much power because you've been harmed
Been
significantly.
harmed. Yep.
Who taught me that? George Gordon taught me that. He's no longer with us, but he was one of the greats. The George Gordon School of Law. He actually had a program where you could go to his farm, work, and he'll teach you as you work. And it was a
Yeah.
private, it was
Remember those days? Yep.
people, yeah. And he was one of my mentors as well before he passed away. You know, he was the kind of guy that, remember, he'd teach you to understand that the police can't entrap you, but you can entrap them. So you have to be careful with entrapment. So read the definition, understand it. But that's what we used to do. We used to entrap them. We used to sit in teams and wait for them to viol one of our community members. But George Gordon took it a little bit too far. Don't take it that far unless you're ready for the consequences. He took it a little bit too far and he wound up passing away. As a result, they could say, but you look him up, he was a really awesome guy, super vicious, educated. I think it was 83 cases or 87 cases against the government and lawsuits. 78 of them won or something like that. 73, 78. He was undefeated. Him, and he studied from a guy named Jerry Spence. So look
Hmm.
those names up and read. Jerry Spence has a whole slew. Jerry Spence is the god of 42 USC 1983. He is the man. There's very few people that can match him, but there are guys that can match him in the world. Buy his books. Learn 42 USC 1983 civil rights violations. There's 83, 84, 85, 6. Uh, and then deprivation of rights under color of law 241, 242. So get these guys,
Yep.
write their names down, research them. These are the guys that I learned from. And just understand they have jurisdiction. It's up to you to change it.
Absolutely. Again, we have to, I always, the one of the most important distinctions about jurisdiction that I constantly have to remind people of is that there are two yous. There is the living man who was living in your body. You know, when they ask you, where do you live? Well, I live inside my body. I mean, that's where you live. You don't live in a building. And then there's the one they create upon birth, which is the birth certificate estate. Another term for that might be a trust or a business. You want to know if it's a business? Go to where they register the trusts. Where go to where do they register it? The Secretary of State's office. What else do they do at the Secretary of State's office? Register companies. Why is your birth certificate in a place where they register companies? Because they had to create an entity over which they have authority. The state creates that. It didn't create you, but your parents created one so that there would be this ability to have an identity to go through this commercial system that we're a part of. We're all a part of that. We still need to use it every day, but it is not you that's on that piece of paper. It is a name. That's why usually it has capital letters, sometimes not, but it's actually what's more important is the fact that it's on this piece of paper in a place where they register companies. So they have authority over the companies. What they don't have authority is over you, the man or the woman, unless or until you cause a harm to someone. Driving down the road a little fast is not causing a harm. Drinking and driving and bashing into other cars or risk putting other people at risk, that might be causing a harm. I don't recommend doing that. We're not here to tell you how to get away with anything, by the way, but you need to know the difference between doing harm and then violating civil or criminal statutes, which don't even point to you. They point to the fiction person they have authority over. Those are called persons, by the way. That word person is a legal term. It's not referring to a living man. It's a person is the entity. You can go look all this stuff up. We got tons of reference material in our material on this, on the premium member area, a ton of downloads goes into all this kind of stuff. And then when we do things like how we sign our signatures, when we do get into a situation where they're kind of like saying, you got to sign or we're not letting you out. Well, okay. Well, then you want to sign in a way which does not bind you, does not put a bond on you. See, the bond is you're agreeing to pay a debt. Well, if I give you a piece of paper that says I agree to pay your debt, what can they do with that piece of paper? They can take that paper and trade it because it's actually got value. It's a performance document. Somebody's pledging to give energy to that document by signing it and to perform, to show up, to pay. That's what a bond is when you get out. You're agreeing that, okay, I agree to go into debt. Leave me out of here. Feels good, but you're now in debt. You got to show up and perform. Okay. You're now the circus clown. You got to come back and perform in court. So a bond is the word, the better word for the word bond is bondage. And we have to give it, we have to sign that. Well, we don't have to sign it. What if I sign it without prejudice? What does that mean, Daniel, if I sign that bond without prejudice? I know you know the answer to this one.
If you sign that without prejudice, a lot of people do the UCC 1-308 signage. You don't need any of that. You
No,
just
that's the code that says you can do this, actually. You just use the words.
so the way I look at without prejudice makes it so that I have the ability to decide what is going to happen down the road. We are
Mhm.
going to renegotiate down the road. I'm not making an absolution when I put that there. I'm saying that if you guys want to negotiate later, bring it to the table and let's negotiate. Because, without prejudice, I, you know, it's what you have to be careful with when you put a 42 USC 1983 and they dismiss it with prejudice. So without
Can't
prejudice,
come back on that.
yeah. So I remember that when I did my first 42 USC 1983, they sent it back. They say dismissed it without prejudice. I was like, man, what did I do wrong? So I went in and I started watching what I did and I said, damn, what did I do? What did I do? What did I do? And I started looking at step by step because they'll tell you what you didn't do, but they won't tell you what to do. You know what I'm saying? I don't know if that makes any sense, but they'll tell you what you didn't do, but they won't tell you what you should do, what you
Hmm.
have to do. So when they dismiss these things, you got to look at it and you got to go by each word and you got to see why they did what they did. So without prejudice means I can come back. I can come back and try again. That's what I figured out. So without prejudice has more than one meaning. Remember that. It has more than one meaning.
Yeah, but in the context of signing something, what you're really trying to say, um, what they're really trying to say is, I'm reserving my right to modify this contract or this agreement. So it's very important to understand that you can sign something with what I call a qualified signature. Unqualified signature means I accept full liability. And then another term is you're becoming the trustee, liable for everything. A trustee in a trust is liable to take care of everything. If you sign it with an unqualified signature, you're accepting full liability. If you say without prejudice, though, you're saying I'm reserving some room, some wiggle room here. I'm signing a little bit, without really wanting to do it that way, but you're kind of reserving. I actually did this once in a federal court case. I had a tax case. Sometimes people look it up and say, "Oh my gosh, he lost a tax case. He went to prison." Well, I never went to prison. I did some probation. No big deal. That was actually the best deal I could have gotten because I didn't know what I was doing initially. But I teach people how to avoid that now too through our tax and trust course. But one time they wanted to put all these conditions. It was like 10 conditions. And the prosecutor was there. Yeah, well, he used to call in every day. And if he wants to spend $100, he's got to ask permission. And it was all these things. And I said, oh, wait a minute. I went before the judge and I said, let me read the Fifth Amendment to you. I'm going to jump ahead into the Fifth Amendment, but basically, uh, nor shall be compelled in any criminal case to be a witness against himself, which means you're just saying anything against yourself, nor be deprived of life, liberty, or property without due process of law. Okay, I'm trying to read it on screen here. And nor shall it be used for public property use without compensation. The key words was, nor be compelled in any criminal case to be a witness against himself or be deprived of life, liberty, or property without due process of law. I read that to the judge. And by the way, I didn't have an attorney speaking, I was speaking. And I said, Your Honor, you want to take away my right to manage my property, which is limiting my liberty, and I can't manage my own affairs without coming to some sort of permission. And these were the conditions of pre-release. They wanted to arrest me and not let me be released. And I said, Your Honor, at this point, you're depriving me of life, liberty, and property without due process of law. Have I had due process, which means all the way to a trial by jury? Has that happened yet? And he didn't answer the question. He turned to the prosecutor and says, take conditions 1 through 9 off that document. And the last one was call in once a month. So everybody else that goes through this with an attorney will be told, just do everything they tell you to do and sign it. I signed it without prejudice as well. And that's what brought the issue up because the prosecutor went, well, wait a minute, he signed without prejudice. And I mean, that means he can just change his mind. Well, he said that in front of the court. And then I read this to the judge, and the judge says, he didn't say I was right. They never tell you you're right, but he gave direction to the prosecutor to drop all those conditions. And I was pretty much left alone, and I did the whole thing, and it went on for 3 years. Them trying to get me to trial. They couldn't because I kept making good, reasonable motions. And in fact, got to the point where the judge even asked me to go to a party with a bunch of other judges so they can meet me. This guy could do, he was doing stuff lawyers wouldn't do. And so I used that because they do that with people all the time with pretrial conditions before they want to hold you and tie you up and limit your life. And I read that to them. And then I asked the question, well, have I had due process of law yet? Because it says you can't be deprived. I mean, you have life, liberty, or property. My time is my property, even. And the judge agreed. They left me alone for the rest of the case and pretty much basically slap on the hand when it was all said and done. So the point is using something as simple as that without prejudice triggered them to raise the issue. And then I pointed out they're depriving me of without due process of law. And there was no arguing against that. The judge had nothing he could argue against. The prosecutor just threw his papers up in the air. Every time we went to a hearing after that, I'd bring up stuff like this, and he'd throw his papers up and again. He got to the point where I'd sit next to the prosecutor. He'd sit next to me and I go, hey, how's it going, Scott? You know, and he'd go, hey, TJ, what's going on? He says, so how many times do you want to keep doing this? So after a while, I started getting a lot of confidence without being too cocky. The point is I knew my rights. I knew how to use it. I knew what a real simple thing like without prejudice could do. And then I knew what the follow-up was, using my rights. So you learn these kind of things. This is the fundamental thing you can learn. And then you'll dance your own tune. But as you are at your law, that's why we're trying to teach people to approach things this way. So that was my long answer to without prejudice. But in a real world example, in a federal court, I actually gained the judge's respect. It was interesting.
Yeah, you have to understand, everybody in here has to understand something. What he did was called an ore tennis or viva voce. So, okay, you have to put things in writing because you want to, in order for matter to be resolved, it has to be expressed. I get it. But if that stenographer is taking down notes and you're locked up in jail and you don't have this here, see, you're good when you can get locked up and you can get yourself out of jail with a pencil or pen or in a notepad. That's
Mhm.
how you know you're that good. So Viva Voce is making them understand you're doing a verbal motion. Okay. And that's what he did. He put a verbal motion in. You can do a verbal motion. Don't let them tell you that you can't. Go ahead, TJ.
No, that's good. That's a good example. And again, the other strategy I use, the one thing I try to remember, there's a few basic things if you remember at what we teach, is always put the burden of proof on them. I didn't just say you can't do these things. I just asked the question. I said, well, if you look at all the things you're trying to deprive me of, does that not equate to deprivation of life, liberty, and property without due process? Have I had due process yet? Just putting things in the form of a question puts you in control of the situation. People have the tendency when they're asked a question to just answer and try to defend themselves. The problem is when you start defending yourselves, you know what you just became? The defendant. And now you're arguing. That's an argument. Just answering is an argument. So I always put things in the form of a question. It makes the burden of proof go back upon them. And it's interesting how they don't want to answer that, but that's okay. Their failure to answer is their agreement that my thesis of the question is must be correct. And it has won me in more situations, even in life, just in general, even in arguments with my wife. If I put in the form of a question, she gets so mad because usually ask a question that there's no way out of. And this is where you get good at doing this stuff. You learn how to ask the right question. I mean, it's one thing to make a statement. But when you make a statement, you got to prove it. So I avoid having to put myself in a position of having to prove anything. Why would I have to prove anything? I'm not the person. right? So if you know, like in the movie, the War Games from like 1977, the end of the movie, the conclusion was the only way to win the game is not to play. Well, by answering, you're playing. When you're asking, you're changing the game. So anyway, that's an approach. What I want to do, if you don't mind, Daniel, I'm going to see if anybody has questions. Let's start with people that are in our advanced training for either the tax and trust course training, the delete debt course. We'll let you guys raise your hands first. And then I'll take it off screen share so we're looking at your bright, shiny faces. If you raise your hand, if you don't mind undoing your camera, but to go ahead and raise your hands if you have questions along those lines. Otherwise, we'll just go into questions of whatever we're talking about. I just want to make sure that people came who are in particular courses can get some questions answered. Okay, Adriana, go ahead. Are we hearing you okay? I think you might be muted or something. We don't hear your audio yet.
Um,
There you
I'm
go.
sorry.
Here now.
Do you hear me? Okay.
Yes.
So I'm in the debt delete course and I have a few accounts. I'm just trying to manage because a lot of it is sort of repetitious. And, I have like two banks that basically put stuff on the docket. I did file the CFPB. It seems like kind of stalled things a little bit. But going forward, just talking about managing all of this, I do like to, write up the case or whatnot, or do the small claims or lease aside for that. But I'm thinking of like maybe outsourcing it, especially if it's like sort of repetitious to a paralegal. I mean, how do people
Okay.
sort of manage, especially the paperwork? Because it's just, I want to make sure I've never
Well, if
done
you're doing
this. So,
a lot at the same time, it certainly can be cumbersome. If it's just one, it's really not that much. It's just one step after. I tell people when you prepare your three documents initially, do them all at the same time, but leave the dates off. So that way, when the time comes to send the second letter or the third letter, you already got it done. You just do prepare it at one time. There's because it's just filling the blank pretty much. But the more you prepare in advance, then when the time frames come, put it on your calendar. Okay, send letter number two, send letter number three. They're pretty much ready to go. That's the way I tell you to sort of because you know how it is. You get busy in life. Something comes up. Oh man, I can't get to that today. I'll get to that tomorrow. So the way you do it is you build out these in steps. That's how I recommend managing it. Now, if you want to have somebody else help you, that's totally up to
well,
you.
no,
That's not on
I'm
me.
kind of past that stage. I'm done with the three letters and, dealing with the credit bureau. And they did, some of them deleted the accounts, some didn't.
Okay, well that's
But
good.
at this point, I'm in the enforcement stage, which means like I want to get to a settlement. So
Yeah.
I did all of that. I've organized my directory. It's all like, tabulated, and the file naming structure is like, has a particular nomenclature so I can list them. I did the
Okay.
timelines. Now I'm just like going through the timelines, sort of listing the violations. But once I do all of that, like actually brainstorm how I want to, the end game, I'm just thinking like if I were to go into a lawsuit, let's say, because some of them, or at least two of them, are like over 10,000, and I know that goes to the district court versus the small claims.
Okay.
I just, as for like recommendation, I just want to make sure that everything's done correctly. Like I don't want to like submit a document and I have a clerical error where I'm like mentioning a different bank or something,
Well,
like I'm
yeah.
so
You might have
paranoid.
a. That would be maybe you need somebody to proofread who
Yeah.
knows has your
A
Right.
information or
clerical, a
something.
clerical error is not going to be a big deal.
It's really not going to be too much, unless
Not
it's
gonna-
the wrong party or something like that,
don't
obviously.
worry about that. You as long as
Right.
they, go ahead.
Yeah, so I just want to have like another pair of eyes because it's a little overwhelming for me, at least like
Okay. Well,
doing it
find
the
somebody that you
first
can,
time.
who's close to you that can kind of follow along and you can tell them to be a proofreader or something.
Or I mean like what about like a paralegal that I could hire or something? I mean, I just want to know like
It'll cost you
logistically.
something. That's up to you. Or just somebody who's just good at reading. Yeah, that's up to you. I mean, that doesn't really matter to us. As long as your document goes out and you follow through, however you prepared it is up to you.
Okay. And my other thing too is because I was looking at arbitration and well, I don't know. I had done a little bit of research, so I'm trying to find like which venue would give me the most benefit, or at least the greatest leverage. And
Well,
so,
as far as arbitration, you need
mhm.
to read the arbitration clause of the parties' agreement that you signed, because that's where you are agreeing to do things a certain way. So be sure you comply with that first of all. Sometimes they want to select the arbitrator. But the idea is if you get to an arbitration stage, the chances are you're at a point where somebody's going to settle something. And I've seen this happen so many times because these creditors will send attorneys to court in an appearance. And this way you can do your objections against them speaking in court, corpus juris. There's just, they don't have the right to speak in court. They're not a witness, so they can't be speaking too much. But when people go in and do that, this usually the attorneys that send are the lowest level attorneys with no experience. They don't even know what the file is in the file. They just here's a file, go in there, go do an appearance today. It's amazing how many times that happens. And quite often, if it gets to that point, they're really there to try to work out a settlement. And so if you see them, you can say, hey, listen, you sure you don't want to just get this taken care of before we go in there? Because that's what the court wants you to do as well. Then you can say, what's the best you can do? And you know how I teach how to negotiate, right?
Well, go ahead.
Okay, it's really simple. It's like, well, what kind of thing do you want to work out here? I kind of did this on my own case because I went to the guy and I said, look, how about we figure out a way to do this without going to trial? I went up to him and said that. He goes, well, what do you mean? I said, I don't know. What's the very best you can do? And he goes, oh, well, it's going to be this, that, and the other thing. I said, yeah, but what if you checked with your boss? What's really the best you could do? He says, well, I'm pretty sure he's not going to do anything else. I said, well, why don't you check anyway? So I'm not being rude. I'm just having a conversation. He comes back a couple days later with this look on his face. He goes, you're not going to believe this, but here's what I can offer you. And I looked at it and I said, is that the best you can do? I always have a second discussion, always second.
Right.
And he comes back, he goes, yeah, that's probably about it. I said, well, why don't we see if we can get that or this or that? I started getting down to the weeds a little bit. And he goes, well, I think we could do that. I said, okay, then I think we got a deal. Boom, case closed. Okay.
I see.
So, but it's how I approach it. I don't ask, well, will you settle with me? No, I say, hey, look, if all things are right and things are, I'm going to that burden of proof thing, saying, what's really the best you can do? And then whatever they say, I don't say no. I just say, I call it looking at the fly on the ceiling. As soon as they give me my first offer, I look at the fly on the ceiling. I'm going like this. I'm watching that fly up there. He's wandering around. They think I'm thinking about something. Really, I'm just watching the fly because it's a timing thing. I say, and I kind of shake my head a little bit now. Can you do a little bit better, or is that the best you can do? And
Is this in
usually at
person?
that point, you'd be surprised what they'll do.
Are you doing this in person or on a conversation? I mean,
I'm doing
like,
it on camera right now. I'm saying it depends. It could be on camera. It could be in person. It depends on the circumstances. Doesn't really matter.
okay.
I like
'Cause
to
like,
act a little bit, so
oh,
in person's better. But if you're not in court, you're literally on the phone or something. People do settlements on the phone all the time.
I see. Okay.
Same
I,
approach though. Two steps.
so when, like, because I've been digging a little bit deeper, and I think I saw one of the messages in Telegram where if you do ask for the chain of title, that's not really required of them. But I really want to get to the point where, if you do the
You
holder
could
in due
ask, but if you
course.
remember the first letter, what it says in
Mhm.
my instructions, in big bold letters, don't forget this is the most important issue. I've yet
Right.
to see evidence that you transferred money from your account to mine. I want to see the evidence that you're even the party I should be talking to. So you get to the chain of title and the wedding signature and all that stuff. That doesn't really go very far. But what does go very far is ask the question. I need to see your witness and evidence that you moved money from your account to me so that I know that you're even a damaged party. Because what we know is we created the credit with our signature on a piece of paper. It
Right.
came out of thin air, poof. So they didn't transfer money to us. In fact, they're prohibited by law from moving their funds out of their depositors' accounts to us. So how can they claim to be damaged by my not paying them back?
Okay.
That's the issue. You got to stay on that. And everybody gets thrown off. They'll throw everything at you. Oh, we verified the debt. Oh, we're an attorney. We said we verified the debt. You're just going to believe that? Did they prove anything to you? No, they're just
No.
somebody talking and making noise.
Okay. I just need to have these
Remember that.
principles
It's,
pounded
that's why I
on.
put those big bold letters at the beginning of the course. Don't forget this main point all the way through.
Okay. But I mean, it's a pretty basic concept. It's
There's no,
just
if a party
ask.
has no evidence that they're the damaged party, that's jurisdiction, the wrong party.
I say. Okay.
That's where the argument goes. They're the wrong party. That attorney sure as heck can't be the witness. That's right out of the
Okay.
law. They can't be the witness.
They weren't at the
Yes.
negotiating table.
Yep, they weren't at the closing table. They're just some person in there making noise, and they cannot. You can object, say objection, Your Honor. This part is not a fact witness to anything. It's even their attorney because they will testify.
Mm,
But if you let them, guess what? It goes in the record. Now it's hard.
sure. Okay. All right.
Okay.
I appreciate you like reiterating these principles because I'm at that point where I really need a home.
Listen, we're all susceptible to that little red herring that flips around in our face. They throw it in right in your face, and it's flipping around that little red
Hmm.
herring. Like, yeah, we verified the debt. You signed a contract. We don't have to produce the wedding signature. We got the chain of title. All that stuff is red herring. It's meant to throw you off. The real issue is who are you? Are you in fact the witness? Show me the witness. Show me the documentation. Show me the proof that you moved money from your account to me. Otherwise, you're not even the right party. Oh, you wanted to speak, Mr. Attorney? Objection, Your Honor. He's not a first-hand fact witness.
Okay. All right.
Shut him
Well,
down.
thank you. Yeah, no, I appreciate it. I did like once I
Okay.
filed that CFPB a complaint, the creditor, the bank sent me again another like statement and whatnot. And it was kind of funny because
We
they've
don't
been
have to
sending
do that.
me,
That doesn't apply. Blah, 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 blah.
yeah,
That's all that stuff. Red
Did
herring.
yeah.
you know? Today I did a video on our 15 USC 1692 G E61. I mean, there's so many 15 USC 1692s, and when you look at that 15 USC 1692. There's G, there's E, there's 16A. All of
Hmm.
those are going to make you much more educated and understanding it. And also, what you want to do is you want to get yourself a. Do you have a Black's Law 6th edition Centennial from 1891 to 1991 pronunciations?
I think I need to get one.
Yeah.
I probably have the fourth.
No, this one is really important to get. You
Hmm.
got to get this one because this one has a lot of, it even has some judicial interpretation in it. It has the USC codes and it goes in on the Latin terms and it gives you understanding. So, Black's Law 6th edition,
Hmm.
Centennial from 1891 to 1991 with pronunciations. Get that one.
Got it.
Get that one right there because that one
Is
there,
this
because
is
remember,
this on a PDF or I should
you
go to
might
the
be able to
online?
get it on PDF, but I'm pretty sure you can get it on. I think this guy offers it on SPC University free. Yusuf L.
Oh, yeah, I know.
He
I know.
offers.
I'm
Be careful
familiar.
of his material, though, because he gets off into some real tangents.
Yeah, yeah. I'm just
Sure.
saying, get that dictionary, you know.
Hmm.
Okay.
But buy the physical copy if you can, used on Amazon. It's like 35, $40. It might have went up, risk goes up, price goes up.
Thank you. All
All
right.
right.
Well, thank you very much. I
Yeah.
yield.
Yeah, yeah. I mean, we have like several places in our download folders in the premium member area. There's a document about 18 USC 8 obligations or other securities of the United States defined. And it talks about, well, what are Federal Reserve notes, what are US notes, and so forth. And then I think it's 31 USC 3126. Let me see if I can find that. I think I'm just referencing off my memory here. Let's see if I can find that really quickly
And in
here.
that Black's Law 6th edition, look up the Uniform Arbitration Act. Please look that up. That gives you a whole plethora of information. And then go into the what's it called? It's right here. The final offer arbitration. Learn that.
I'm gonna look something up here while you talk.
Thanks. Thank you.
Yeah, the
Thank you. This
Uniform
is really good
Arbitration
stuff.
Act. That gives you a whole plethora of information on what they have to do in regards to negotiating with you. They can't break certain rules. Okay?
Hmm. Okay, got it. Black's
So
Law
yeah, know the
ditches.
rules. Again, the arbitration rules should be stated in the arbitration agreement, but also you're going to have your own rules for the jurisdiction you're in. There's back to that jurisdictional questions. You got to look things up, you know?
Uniform
Got
Arbitration
it.
Act is sweet.
Here I've got,
Okay.
so this is an interesting one. I'll pull this up here real quick. I got them both here. Yeah, okay, here we go. I've covered this document a lot, but this has a lot to do with, what's going on. They're charging you a tax when they're charging you a ticket. What do they want you to pay in? US
Bill,
notes and things like that? Well, that
Bill.
could be a problem. Let me just share this really quick. So, 31 USC 3124, you can go look this up. Stocks and obligations of the United States governments are exempt from taxation by state and local political subdivisions of a state. The exemption applies to each form of taxation that would require the obligation, the interest on the obligation, or both to be considered in computing a tax. Now, you take that code, stocks and obligations of the United States are exempt from taxation. Now, what is an obligation of the United States? Well, let's see over here. What does 18 USC 8 say? The term obligation of the security of the United States includes, by the way, when it uses the word in the law, when it says includes, it means only includes what follows. It doesn't mean beyond that. It's not an assumption. All bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Bank notes, Federal Reserve Bank notes, coupons, US notes, and so forth. Now, go back to what I just said. Stocks and obligations in the United States are exempt from taxation by a state or political subdivision of a state. So you read these things in more full, you're going to find out what they're telling you is just the receipt of that document doesn't make it taxable. Yet we pay taxes based upon that. Okay. And now they want to be paid, by the state wants you to pay something using those instruments which are not taxable, yet they're charging you a tax.
So does
So that
that
document gives you a general idea how you can look at those kind of things.
you had another document as a follow I don't recall it. It was in the bonus section regarding the 1099. How does that tie in? Or does it not? I'm just trying to like really
I don't know
understand,
what
put
you're
all the pieces
referencing
together.
regard 1099s can mean many, many things. So I don't know what you mean.
I mean, do you file a 1099 on an account or
Well, if somebody doesn't pay you a debt, usually a 1099-C, which is a
Mhm.
cancellation of debt, you would file to charge them with the obligation to pay that tax. If
I
that's what you
see.
mean by 1099, 1099-C, A, OID, there's a lot of 1099 forms. So, and then the context matters when you ask that.
I see. When
Yeah.
would the 1099-A be used?
Well, that has to do with the abandonment of debt. That's a big, big discussion. I probably can't even start to go into that here that's beyond
Okay.
your first question. But trust me, there's a course on it.
Okay.
But an A is an abandonment of debt. When you say they owe you a debt and they don't pay, you abandon it. And then there's a report of that. And you can kind of take a tax deduction, take the tax credits back on that. But that's a whole section. We have some information on that in the tax course. If you're a tax course member, if you're in the combo pack,
Yeah.
there's some data in there about that. You can look that up. Way too
Okay.
much to do here today.
So
Okay.
the two things that you cited, the 18 USC 8 and the 3124, how does that tie in? If let's say they delete the debt, of course they're gonna say, well, you're
Well,
gonna
it's not
have to
really
pay
about that. This
taxes.
is more about they're charging you, wanting you to pay in something that's not usable. Okay. Anyway, that's a whole other
Okay.
discussion. Um,
Okay.
yeah, it's not directly about that. Yeah, but if you send them a bill for the non-repayment of your original note, see, when you created these documents, you created a note. They've never returned the note to you. That's your property. But they're saying you owe them a debt. Well, wait a minute. The debt is an instrument that can be used to discharge a debt. Why aren't they applying that to your debt? Because that's what you should be doing. That's a discharge. But if you didn't do that, then they never returned your note, so they owe you something. Well, if they don't pay you back what they owe you, and you send them a bill, just like you get bills, and they don't pay, well, that's you say, well, I guess I'll cancel that debt. Well, when you cancel it through a 1099-C, again, you have to set up a process. Once you cancel it, now you have unpaid debt that's owed to you They need to pay the tax on it because it's as if they received the money, but they owe you money. And you start charging them interest. Well, if it's unpaid, you can actually, there's a way through the process of doing this that you can actually take those as tax credits against any future debts or tax debt you owe.
I see.
That's deep in the tax course though.
But when you say the document, are you talking about the validation letters or just the promissory note or the credit card agreement where you
The
just
original
sign?
document you signed created a instrument that
Okay,
one upon which they created money. But they never returned back your property, the original instrument. That has value.
that's true.
If it didn't have
Mm,
value, how did they go make money out of it?
yeah,
But they never returned it to you. And then later on, you want us to offset or discharge it. Well, this is all just a paper game. You gave them
yeah,
$100 Monopoly money, they gave you $100 Monopoly money back. Well, wait a minute, then how can I still owe a debt? Because they didn't take it out of their vault. It's not their property. They couldn't be the party making a claim against you because they can't prove it. Everything's got to be proved with authenticated evidence. Somebody making a claim against you. Authenticated means a witness with firsthand knowledge. That never happens in these situations. Therefore, you're not saying, I don't owe it. You're saying, hey, I'm happy to pay it. Just bring the proof with the witness. But without authenticated evidence, they don't have evidence of their claim. Therefore, they can't really be a party in standing. It's about standing. Who are you? Why are you here? Why is there only some attorney making noise over here? Where is the proof that you gave me assets, hard assets? And then if you don't have that, then why are you here? That's your position in all this. And that's the basis of the delete debt program. Okay? Any
man.
other callers? We're going to take any other hands up? I
thank
don't
you.
see any right at the moment. You bet. Good questions? We get other people a chance. We don't have anybody with their hands raised. Go ahead. Anybody else got your hands raised? Otherwise, we're going to be done pretty soon. Hasta mañana. Hasta la vista, baby. Give people a minute here. There we go. D. Ooh, somebody's being mysteriously anonymous. D. I think, are you unmuted, D?
Yes, it's actually sunny. Hi, TJ.
Hi, Sonny. How you doing?
Good. How are you?
Like Sunny D.
Yes.
All right.
I was just gonna ask about the. Can you explain a little bit about the crypto you posted recently?
I I wasn't really ready to go into that. If you ask the question in the crypto group, I can certainly give you a link to go check out, go
Mm-hmm.
look into it, just kind of explore it. And once you create an account, then ask me some questions. It's free. It doesn't cost you anything. But take a look at how to set it up. But essentially, there's two different platforms that we've seen. One of which is sort of a hosted platform. The other one where it's really your own account. It's just trading the cryptos. What people don't understand is that cryptos are getting traded just like all other currencies around the world all the time. And it's the middlemen that make the money. And these guys have a trading platform where the crypto is getting bought and sold. Somebody funds the transaction, and there's a little profit generated on every transaction. These could be happening thousands of times an hour. And when you do this platform, you essentially kind of getting paid some of that margin between the trades. That's a very short, simple way of explaining it. But it's at this point, my account's returning close to 15% a month return. Now do the math, 15% a month times 12, right? Is
Mm-hmm.
about 180% a year. Now, I'm not guaranteeing that. I'm not saying that's what you're earning in interest. It's profit by the movement of money between parties. And there's a participation in doing that sort of thing. So that's what that platform is all about. Again, I recommend you just go in and you sign up for it. I'll send you some, you're not spending any money. You're just getting a position so you know how to log in. If you already have crypto out there, you can transfer in, then there's a way to buy into the account once you want to make a deposit to put it into your own trades. And don't
Okay.
compare it to anything else you've seen out there because I've seen other things. This is not the same.
Okay. So it's like no minimum deposit that you got to make.
There's two. I think one has $1,000. The other one is, hundreds of thousands. I've seen people with millions in it because
Okay.
they're doing very well with it.
Okay. All right.
Yeah. And
Thank
I
you.
personally met the principals in both of these programs. I don't deal with these kind of programs unless I can meet somebody real and live.
Oh, okay. So you've
There's
been
too many
doing it for a
anonymous
while.
programs that I don't like.
You've been doing it for a while now. Okay.
Yeah, yeah.
All
I
right.
met a guy from Hong Kong. Turns out he's the actual trader for this multi-billion-dollar platform, and they're the number one rated um, platform in But was it Binex? I forget the name of it. Um, um, anyway, they're apparently the top trader in that account.
Oh no, I have Binex. I was talking about the one that you posted recently, like a
No,
couple
no, not
days ago.
Binex. I'm sorry.
Oh.
I'm thinking. I'm forgetting the name of the actual account provider. Oh shoot, what's the name of it? Anyway, it'll come to you. But it's not Betnex. That's a different
Oh,
thing.
okay. Okay.
Yeah. Yeah. Anyway, but go ahead and just sign up for it. Then send me a message, and I'll send you a link to watch some videos and information on it.
Oh,
I
so you
just want
have
to know you're already in the game. Then I'll send some stuff to you.
okay, so you have videos I could watch. Okay, I will send you a message
Yeah, I'll
because I
send you some
did.
information.
Okay,
Yeah.
okay. I'll private or through the Telegram.
Just well on Telegram, or you can send. You can also through Telegram click on private message, and I'll send you the video links on that.
Okay.
Or down. There's one that just says to download. And
Okay.
then if you have other questions, we can get you on a webinar to ask questions.
All right. Thank you.
Okay?
Because I just want to get more
Yeah.
information on it. All right.
No, it's really good. I mean, in fact, Daniel and I are going to be talking about something soon relevant to that,
Mm-hmm.
where we can show you how to raise a whole bunch of credit. And, one of the things that the wealthy do, people don't understand this, is they use credit. They don't use their own
Mm-hmm.
money. So you borrow money at 10%, but if you're in 20% on it, you're making money on credit. This makes way beyond that.
Mm-hmm.
So we'll talk about that as a strategy soon.
Okay. And then I just wanted to give update. I had court on Monday for my debt collector, but the judge ended up giving me a continuance because I had so many cases filed. So my one with Sally Mae got moved. They moved it to federal, and then the one with the debt collector, they didn't ended up in. They didn't show up. And I had got the other class that you recommended with the
Uh-huh.
procedures.
Yeah.
So the judge ended up giving me a continuance. He said just to file it in the right case. But yeah, they didn't end up showing up. So I have to go back to court, file it again, basically. So I just hope they just don't show up and then I could just do a summary judgment. So yeah.
Yeah. Yeah. And typically they really don't show up. They don't
Hmm.
show up prepared, and whoever shows up is not a witness.
Yeah, yeah. Oh, yeah, because I had submitted my memorandum um for the debt collector for the Sally Mae case. They're supposed to reach out to me, see if we can do a settlement because that's what the judge ordered. So
Yep.
they haven't reached out yet, and it's been like it's almost 2 weeks. So I'm probably going to reach out to
Okay.
them.
And like I said, when you reach out, say, yeah, I understand we want to work out a settlement. I just need you to provide me one little bit of information. Can you give me the name of the witness and the actual accounting ledger showing the money moved from your account so I know that I'm giving the money to the right party?
Say that when I try to settle.
Yeah, that's
Okay.
like I said, you never give 100% on the first offer. So you say, well, okay, I'm happy to settle, but I just need a little verification. I need to know that you've got the extra, what I requested in my first letter was the accounting, not my accountant sheet, the sheet they give you of your account. I'm talking about the movement of money from their account to you. There's got to be a ledger of that somewhere,
Okay.
which of course doesn't exist because that's
Yeah.
illegal. But
Yeah.
it makes them the party and standing. So I'm going to send you the money. I just want to be sure you're the right party.
Okay.
And then
Okay.
they're like, oh, well, okay. I'm just telling you, just do this anyway in hopes that they actually throw you even a better bone.
Yeah. Okay. So yeah. I
Okay?
should. Yeah, I should do that because they're just dragging it out at this point.
Of course they are, because you're asking the right questions.
Yeah.
When you're over the target, you'll get the flack, but you got to stay over the target
So
until they stop.
I should ask for that first because like I said, they're supposed to reach out to me.
Yeah. And like I say, you're always reaching out to resolve it. Hey, I'm the
Yeah.
good guy, but I
Yeah.
do have a question for you.
Yeah.
As Paul, like the TV show Columbo, Daniel kind
Hmm.
of looks like Columbo in a younger version, right? But he would do a talk. He would interrogate the little old lady. Your husband was found over here dead. It's a terrible, tragic thing. I'm really sorry, Mrs. Johnson. I'm sorry about all this. So he goes, but I'll tell you what. Obviously you're an innocent lady. You have nothing to worry about. So I'll be back to you tomorrow. And he'll walk over to the door, and he'll walk and reach over to the door, and he'll say, "Oh, Mrs. Johnson, just one more thing." Well, that's where the dagger is about to come, right?
Hmm.
Just one more thing. Why was it that your fingerprints were on that knife? How do you explain that? And then she's like, he gets them to lower their guard, then he hits them. That's kind of what we did with the attorney. Hey, we're willing to work with you. We're willing to figure all this out. Let's get this element done. I just want to ask you just one more thing, Mrs. Johnson. Where's that witness that can prove that you gave me money? I just need to make sure that I can speak to them and see the documentation, and I'll be happy to get this taken care of. It's an impossible question to answer, which forces them to possibly give you a better offer.
Okay.
Or sometimes they just don't show up when you start doing that stuff.
Yeah. Okay.
We've had people hear it say, yeah, they didn't show up.
Okay.
No
Yeah.
guarantee, but that's kind of it's how you play it. It's a little bit of a game. Okay.
Yeah. Thanks for that tip, TJ. I needed that because I'm
Yeah. Okay.
tired.
Good.
I'm
Good.
tired
Good.
of keep going to court dates and we keep dragging it
I
out.
hear you. I know this is exhausting, but every time you go, you're growing. You're
Yeah.
doing
Yes.
something.
Every
You're
time I
not living
grow,
in
I mean,
fear. You're not
yes.
living
Every
in
time I
fear. You're
go, my
just
nervousness clears up. So that's good.
exactly. But that makes you so much stronger. You know, you don't get good. You don't get to a Super Bowl as a football team by just practicing
Oh,
and
and
reading about theory of football. You go by fighting through the battles, and every time you play, you get better, and eventually you're good.
And you know what the judge also ordered too? I guess like all the judges signed off on it. It said to also cite to make sure that you are not using artificial intelligence. And I didn't use AI. I only use AI for structure, but I use that how to win without a
Well, my
lawyer
response would have been,
case.
well, Judge, I'll be happy to do that. I'll have to show you that I'm not using artificial intelligence as long as you're showing me you're using any intelligence.
Okay.
I knew that was
Yeah. Yeah, they ordered for that. I'm like, okay, I'll do that.
Yeah, better than none. So, okay.
Yes. Thank you,
All
TJ.
right. Yeah, got another call here. All right, good. King. We got the king here today. Wow. Go ahead.
Hey, TJ, I would say a king, not the king.
Amen.
All right, right on. So, first of all, let me express my gratitude, to you for setting up this meeting and, making it this platform that we can, exchange education here with each other and, salute you
You're welcome.
personally for, yeah, of course. I am a new member and I have watched quite a few of your videos and I see that they're time stamped going back as far as 10 years. So I just want to, salute you for your commitment and for things that you have done in the past and continue to do.
Thank you.
Yeah, to help all of us and, help us grow. Would it be a problem if I asked 3 separate questions?
If you can make them fairly brief because we're beginning to run a little long, so go right to them. Not too
Okay,
long a
sounds
scenario.
good. All right, great. Well, I'll start with the subject that we've been on, which is the debt
Let
deletion
me ask you a question. Which course are you in? Are you the premium
and
member,
the
delete debt, combo
delete that.
gold, delete debt? Okay.
Delete that. Yes, correct. So I'll start on that one. It sounds like it's sort of piggybacking off of D and the previous caller. So I've sent letters 1 and 2, and just today I was getting ready to send number 3. Didn't make it to the post office in time, but I did get an email from Experian stating that the dispute has now been resolved. And when I went to check on the account, it basically says that, the investigation has been completed and, the dispute, it stands. There's
They'll
no
say it's
change.
down. They'll say there's no dispute or whatever. That's typical.
Correct, yeah. So then tomorrow I'll be sending out number 3.
Keep going.
So, yeah, so I don't really have
A
much to
non-answer
report.
is not an answer.
Yeah, they haven't answered. Yeah, correct. Yeah. So, that's the way that I'm taking it as well. I'm going to go ahead and, see the entire process through before, making any judgments on how, it's
Okay.
going.
What's your next
Um,
question?
the next question has to do with traffic tickets. So, I do have 2 traffic matters. Neither one of them involves any injured party. One is a speeding ticket. Is what we call a speeding trap or whatever, speed trap. I don't know if they call it the
You
same
said it
around your
does
way.
not involve a damaged party. Is that what you said?
That is correct.
Okay, so it's a speeding ticket. Okay, what's the question?
Okay. So I went ahead and give a notice to the clerk of court to sort of like reset the date or push it further out so that
Good.
I can, yeah, and so that I can go ahead and get my paperwork in. The second one was a minor fender bender. There again was no injured party. The other person was not harmed physically. They had no medical issue. It was
Did the
a
police show up?
small.
Was there any citation issued?
Well, the police did show up to my house about an hour or two later
Okay.
because the gentleman was very unwilling to exchange information and handle the matter between us. And I was less than a quarter mile from home. I had a couple of emergencies, and I said, "Look, I'm going to take off," and I just drove home. He
Okay.
followed me, you know,
Did
and then
they accuse
eventually
you of a
the
hit and
police showed
run?
up.
Or
Yeah, so I got a what they call a reckless driving for leaving the scene without exchanging information.
okay.
It's not a whole lot of money, but again, with that one, I also put in a notice with the court, and they pushed it off to July for a hearing.
Okay.
Okay, so
All
those
right.
are those two. Yeah,
Okay.
and so my question with that is, I've watched the video on expressing the trust. Does that ring a bell?
Yes.
Okay, I've watched it several times. Funny because you started by saying you should watch it several times and listen to the details. It seems to me like that might be the approach for me with this matter, to go ahead and file that document. Unfortunately, I have not been able to find it in any of the folders. Would you be able to?
The express the one on expressing the trust should be in the folder that says, I think it says trusts and bonds. I think it's in there.
Okay, I'll go ahead and take another look again tonight when I get home.
Yeah.
Trust and bonds. That's
I
the
think
folder.
that's the name of the folder, something along the lines. There are various links on the premium page, but there's one about trust and bond, and that would be expressing the trust.
Okay. Yeah, in the video you mentioned something about, you should send it to, the prosecutor and to the judge privately. Unfortunately, here where I am in Broward County, Florida, in Fort Lauderdale, they don't tell you who the judge is. It just says hearing officer.
That's fine. Give it to somebody in an official capacity for the time being. In
Okay.
traffic, they usually don't assign a judge till later anywhere. Danny, you do a lot right there in that county. You're in that courthouse a lot, aren't you?
At courthouse every day.
Yeah, he
Oh,
knows
is
that
that right?
courthouse really well. Yeah.
Okay. Hey, Dan. All right. I think I saw one
Well,
of
what
your
would you
videos
say
on
to him?
YouTube as
I mean,
well, Dan.
I got a way I direct him. You could use the express the trust method. You could also use the discovery method and ask some pretty hard questions. For example, did you settle with the guy? Did you pay him something, or did you take care of the matter?
Oh yeah, he's been paid through my insurance.
Okay,
The property
okay.
damage. Yeah, the
All right.
property damage, which was to his rear bumper, has been
So he's
addressed.
making the claim that you just didn't even try to talk to him. You just need to, you could discovery request him out, you know?
Yeah, well, right now it looks like they are only filing the ticket for the reckless driving. The other
That's just,
one,
yeah, it's a serious though. You got to get rid of that because
yeah,
reckless
yeah.
doesn't, what is the definition of that? How does the statute read? The words may matter to define that they got to prove that that definition even applies.
Yeah, I looked up the statute, and it does say, leaving the scene after causing $500 of property damage without exchanging information, whatever.
Okay.
Um, but it's interesting because they gave me two citations. One is a monetary one. I think it was $165. That might sound familiar to Dan because it seems to be that's the amount that they put on there, either 155 or 165 in Broward County.
Pretty
And
small.
then the other one requires an appearance. But when I go on the Broward County website to see the citations, they only filed the monetary one. The other one, they didn't even file it, like it doesn't even exist. Like they're not trying to pursue it, it appears. And when I call and ask the clerk, they're saying the officer can file it at any time, even months later.
Right. Well,
So
certainly,
that's that.
one way is you approach again, you can do a discovery request. Like our discovery request in our traffic folder gives you a whole bunch of kinds of questions you can ask. It annoys the crap out of them and basically puts the burden of proof on them to prove certain things. Lack of proof or lack of a witness, it dismisses the case. But I want to hear what Daniel says about this scenario.
Okay.
So the traffic situation, I'd change it to federal because they're not even going to listen to you in that uh that jurisdiction. I'd change it to federal, and then from there, I'd go Kenesha Mills versus the District of Columbia, you know, and I get cases dismissed with just two things in the complaint. Uh, Kenesha Mills versus, I got to get that. I just did a video on it on my channel, and 50% of the times it gets the tickets dismissed. So the traffic situation, traffic is a really funny thing. They make me laugh with traffic. Um,
Mhm.
so going in there, you mm, so you got to have a traffic is a great way to practice because they're small. It's not too big of a deal, but you can still get arrested. You know, if
Yeah,
you
this is crazy.
you can still get arrested, but you know, court is going to be your best teacher, and tickets are what you want to practice with when it comes to court. So, you know, you're in Broward County. You can actually see me tomorrow at the law library there because they have a $20 million law library in Fort Lauderdale. These people pay a lot of taxes for that law library, and no one ever uses it. So that traffic incidents, you got to once you change it to federal, they'll never be able to get in personam, subject matter, and in rem. They'll never be able to get all three. They might get one jurisdiction, but you're going to kill them on it if you're me. So, but if you're me, you might get locked up too, because sometimes I'm so good at it and I've gotten so used to it that a lot of times I try to make them look bad, you know, and they don't like that. So
Okay. All right. Does that
Sounds
help?
good, Dan. I appreciate that.
Look at our traffic folder as well for some ideas on discovery. And part of what he's saying is you moving it, you basically to try to have the jurisdiction moved. And then there's federal jurisdiction is where, real things are heard. This is just a local administrative court. And they're trying to take money from you without due
they won't even,
process.
they won't even listen to you. They won't
Yep.
even listen to you or shut you down. But I like to play there. I like to play in state court. You know, he'll say, you know, I'll ask the judge, uh, you know, I go free. I'm like, hey, you know, I ask them, could you please, because I like to ask for the jurisdiction because remember, there's only two jurisdictions that have a criminal ingredient to it, common law and admiralty. I'd like to try to, I'm getting really good with trying to get them to admit it's admiralty because once they admit it's admiralty, you get the case dismissed. I had one time out of, I can't remember how many times he did say it was admiralty. Then I moved to dismissed it just to get me out of there. But
Hmm.
they'll admit it every now and again. I've only seen it one time. So you want to know the jurisdiction. Why? Because if they don't tell you what the jurisdiction is, you got a lawsuit.
Yeah.
You got a
They're
lawsuit.
depriving you of knowing what this is even about, the nature and cause.
It's
That
incumbent,
includes the jurisdiction and why.
it's incumbent upon them to tell you. You want to know the jurisdiction. And a lot of times they'll say to me, I don't know what that is. I'll say to them, Honorable Judge, I prepared, I've took the liberty to prepare an affidavit for you with your name on it, not your, I get a little bit tongue twisted, but I have an affidavit with your name on it because you can ask the judge for his name, not his title. And usually, if he gives his title, they leave it off the public record. So if you ask him for his name, and you get him to say his name. Now his name is on the public record. So you say, I took the liberty to prepare an affidavit in your name. Would you be willing to sign it under the penalty of perjury, accepting full commercial liability to what you're saying is true? And this quiets him up for 10
Real
seconds.
quick.
10 seconds. They just turn around. The prosecutor just turns around, puts his back. I always like to use a public defender because I like to see him, because you can use that. You're being honored by giving a public defender. You don't refuse that. You take it and you go through the process of getting rid of him. Okay. You don't just fire him right then and there or just go without him, because then you go into dishonor. So what I like to do is, and the public defender would just be like in shock, like he doesn't even know what's going on. And the judge is the only one that does know what's going on. And they quiet up for literally 5 to 10 seconds. When they quiet up for 5 to 10 seconds, you're winning. You got them in a chokehold. Put them to sleep, because they're going to do the same to you.
Yeah.
Right on, Dan. I appreciate that. Thank you very much. I guess let me show the camera. I'll look for you at the library then.
Yeah, you'll probably see him down
Is
there.
the camera on now?
It's the
Seems
guy
like
with the
it's
sleeping
not,
bag and the cot in the corner.
There you go. I see you now. You got your
Is that right? There we go. Okay. All right, Dan.
got your top hat.
The guy in the cot. There you go. And I'll look for the guy on the cot with the suit. No worries. All right. But yeah, so I did have a third. Is that a problem if I get into the third and final?
Go ahead. Make it kind of quick because we're not trying to move it along.
Okay.
Sure.
Yep, I'll do my best to sum it up real quick. So I know that this subject is a touchy one for many people, and it has to do with child support. And I know that the first thing that comes to mind with that is, people could be a deadbeat parent, someone's not taking care of their child. I'm one of those people that also feels that way, that, no parent should abandon their child, and that's their obligation. I do want to say that the case and the matter that I'm speaking of, he is now 23 years old. And through his lifetime, from the moment that he was 5 years old, when my ex-wife and I separated and she started the case in family court, I have contributed $100,000 or more to his entire upbringing. So I never neglected him in that sense. Unfortunately, this is from New York, and they have this, instead of the age of emancipation is not 18, it's 21. And throughout all those years, which is almost 20 years that this went on, there were moments, where I was unemployed or underemployed, and there were months where I wasn't able to make payments, and then I would restart again once I was able to do it again. In any event, those months, whenever gaps existed throughout the years, amounted to accruing arrears. And now this arrears continues to accrue every month, and it's literally a financial noose, to the point where when you do the calculations, the interest that they charge of the arrears outpaces the principal. And if I were to pay it on a monthly basis at the minimum rate, it would take me another 14 years just to pay the interest.
Okay, some background. Is that in your background?
I'm looking to see if it's raining really heavy out here right now. I can't hear you.
Oh,
Can you
okay,
repeat
okay. I hear you. Yeah.
Let me mute it so I can
Okay,
hear
what's
you.
your question though? What's your question? So they're saying you're behind on child support.
The question is, would I be able to use equity somehow to deal with this arrears and get that removed? Because the last thing that happened was they revoked my passport, and I'm no longer able to use my passport.
Oh, well, until you create that fix, of course, the passport, they do control that because they control the person. The passport is the person's passport, which is the state's passport. Again, it's not mine. It's never yours. So you have to start with that mindset so you understand how to address it. It's tough. I mean, until you get it resolved or get an agreement or something along those lines, they're not going to let go of that. They really use the passport as a tool to control the child support.
Child
Um,
support is simple. When I see you tomorrow,
yeah,
I'll show you where the paperwork is. Don't worry about it.
yeah. I mean, the bottom line is, if you make it a federal issue, I think that's probably where you go with it,
Here you
because
go.
it's because it's a deprivation of rights under color of law of the state making your child its property and making you pay them. It's pretty bad. So anyway, get over to the federal side. I think you'll find the answer. Yeah, talk to him, Daniel.
And not only that,
Sounds good.
the Minnesota Supreme Court already ruled that child support is unconstitutional. So your cookies, all you need to do, the thing with child support is just like anything else. They're going to drag it out and they're going to make it. It's not, you don't have to explain yourself about being a deadbeat mom or a deadbeat dad anymore.
Yeah.
Not going there anymore. It's not, you don't even have to say that anymore. People think that, oh, if I say about this, people are going to think I'm a deadbeat dad, deadbeat mom. No, it's not even, don't even go there anymore. So child support is a simple thing. It's just drawn out. All you simply do is ask them for the binding contract.
The
Same,
contract. Exactly.
same thing.
And they're removing your rights without proving evidence they have a contract.
Don't traverse. Whatever you do, do not traverse. What I mean is, don't when you argue, you create a material issue of facts. If I walk up to you and punch you in the face and I don't knock you out, what's your natural thing going to be? You're going to ask why. Why'd you do that? And try to hit me back. You got to take it like that. You got to, look at it in a way where if you get punched in the face, the best thing to do is remove yourself. Just remove. I'm gone. I'm out of here. Now, that's in an ideal world, but don't worry about it. Tomorrow I see you. You understand what I'm talking about. All the papers are right in there. It's in family law. Who's got the next question?
Sounds good. Thanks a lot, gentlemen.
Oh,
Appreciate you both.
yeah. You bet. You're lucky you're right there where you can actually go in there and meet. We'll do a follow-up and we'll talk about what the remedy might have been generally. Okay? Next time. All right. Karen Lee. Okay. Let's try again. Didn't unmute.
Oh, unmute. Okay, fine.
There you go.
Yeah, this is a trust question. My sister died in December and she left a trust, but I don't know that it was properly funded. So it was like 30 pages. The last page is written, her mobile home is on there, her jewelry, her car, bank account, which she had not made anyone a beneficiary of. So what's involved with actually funding the trust? I'm told the trust was not funded.
Well, are you a beneficiary of this trust, or what's your relationship to the trust?
Yeah, well, actually, yes, I am.
Okay. Who is the trustee?
The trustee is an old boyfriend of hers who
Uh,
no, but
Wonderful.
yeah, that sounds bad.
no, there's no problem there. He's a very, very
Okay.
nice guy. We live in
Okay.
California. He lives
Well,
in
okay.
Louisiana.
So it really trust questions always come down to what the contract says, because all a
Uh-huh.
trust is a private contract between parties.
Right.
What does it say it's supposed to happen?
It says that my other sister and I are supposed to get X amount of dollars, that the SPCA is supposed to get $25,000. Now, actually, I don't think there is an SPCA. It's actually ASPCA. So I'm hoping the fact that that wasn't even written correctly, that would rule them out. And then my daughter gets the bulk of everything, which is a mobile home. She paid $500,000 for a car, her jewelry, but it's just, it's just the last page of the 30th page of her trust. Just those things are written down. But the attorney we're dealing with says the trust isn't funded. Oh, here's the other problem. We haven't actually found the wet signature on the trust yet. The attorney who wrote the trust in 2011 is dead, And the attorney we're dealing with tells me, and I believe this, that attorneys don't keep wills. They don't keep any of that kind of stuff.
Mm-hmm. Yeah. Unless they made some sort of formal custodian for that purpose. Yeah, those things are, they just help draft the stuff. Yeah, trust, this is a very complex question because it really has to do with what do they mean by that? What are they saying? If it wasn't funded, a property is funding, so it doesn't have to have a dollar, of US currency. It
Mm-hmm.
has assets. So to say it's not funded is just not accurate.
Mm.
So have you been to court on this issue or something, or what's going
No,
on?
we're trying to avoid probate. I guess if we
Yeah.
can't find a wet signature on this trust, I guess that we can't. It's
Yeah, it's probably
invalid.
going to default if you have an invalid document, then maybe because there's no signature and there's nobody to verify the signature. That's why you do things with notaries and things like that because they become your fallback. If it doesn't have that, then yeah, you got a piece of paper. It's like you hand me a contract for a loan, but I never sign it.
It
Is it
was
worth
notarized.
anything?
It was notarized. So our
Well,
copies
so
show
somebody then,
notarization.
okay, then go to that notary. The license number should be available.
Uh-huh.
So there is a notary on it. Somebody signed it,
Right.
right? So then you still may have to go through either an arbitration or a court to enforce the contract. And of course, the
Mm-hmm.
trustee would have to go do that. I mean, I
Mm-hmm.
don't know I guess I don't know why the trustee's just not doing their job of distributing the assets.
Oh,
There
well,
should
the
be no
trust,
court.
well, because at this point, with the attorney we're dealing with, she's acting as if there is no, that the trust is invalid and that we're going to have to
Wait,
go to
wait, wait, time
probate.
out. The trustee you're dealing with, your attorney?
Yeah, the one I hired.
Okay. Okay, so what are they saying the remedy is?
To go to probate.
Very likely then.
Mhm.
They know their probate laws in that state. This is where you do get into things where sometimes attorneys can help, obviously, because they're very specialized. Probate and marriage laws are very hard to do anything fancy with because honestly, it comes down to two parties arguing over a point and a document.
Mhm.
And that still applies because there's a contract to be dealt with. Marriage is a contract, and so on. And especially when you sign it through the state, because now the state becomes a party to the contract. That's why
Mhm.
they get control of your kids, by the way. You
Mm.
sign them over to the state.
Yeah.
Same thing with the probate. This is why we say do documents correctly, so you don't have this problem. Otherwise, you will have this problem.
Mhm.
And if it's not properly signed, notarized, there's not a living trustee to manage it. Yeah, then if in doubt, then it's got to go back. That's how all the states are handled by the state, because the state, remember, has birth certificates and contracts, marriage certificates. All these things have to be factored into dealing with this, unless the document is good and and done properly, because then it overrides. But in law, the contract is the superior law. In this case, might have an invalid contract, therefore the state has to resolve the dispute if the parties cannot resolve it
Mhm.
privately.
Okay.
That would be the general answer.
Mhm.
I don't know the
Thank you.
state laws, don't know what they say, but that's probably a general principle of how you have to deal with it. Unfortunately, again, if you had a good trustee and the proper documentation, they'd just start distributing assets. That's their job. But apparently there's a defect in the contract. So now you got to resolve that.
Okay, so you think so there's a chance if we go to the notary and get documentation that he notarized my sister's signature, it could go forward without a wet signature.
Well, you still may have to go to court to make sure there's a clear determination that it's still good. This is possible.
Uh-huh.
Don't know what's going to happen. I don't
Okay.
make predictions.
Mm-hmm.
And an attorney prepared that trust. So
Yeah. We try to teach people how to do a trust, obviously, right, and to understand it, and that there's a primary trustee and a contingent trustee who understand what the directions are. So if something happens, there's a backup and everything can flow through correctly.
Mm-hmm.
But without that, you can't fix the Humpty Dumpty fell out the wall. All the king's horses and all the king's men cannot put Humpty back together again. That's why you don't want to you want to protect that from happening because once it gets to a certain point, it's messy, and that's again kind of the purpose of court is ultimately to resolve the unresolvable. But all the parties should resolve the issue privately first. And if they can't, then that's the ultimately court has to make the determination based upon the rules of the state.
Well, if everyone agrees, my sister and I and my daughter who's receiving everything, if we agree that we don't have a problem with the trust and how it's distributed,
Okay.
then should we be able to go forward?
You'll have to ask your attorney that question because that's a really specific, he's seen the documents. I haven't.
Right.
He knows what the court does. I haven't. But certainly if you all agree, walking in with an agreement, the court always wants the parties to agree before they come to court. And you come to court and say, well, you all agree to distribute according to the trust. The judge will probably simply say, well, then do as the trust says. You already agreed to it. Now, they could do more with probate. I don't know the rules, what that state does in those situations, or the
Mm-hmm.
court or the judge. I don't know what he might do in that situation. But generally speaking, if you come in with a good, solid agreement that we want to execute the trust as is, there's some missing elements here, but the bottom line is it's if it's still valid and the trustee can show up and say, yes, I'm the trustee, I agreed to do this, that's probably all you really need to do, I think.
Mm-hmm. Okay. It's actually in my favor, my sister's favor, if we don't go with the trust, because my daughter gets everything pretty much.
Okay, again, that's gets to get into the dispute of he said, she said, I think, you think. And that's all like, okay, that might be going beyond what the trust says, and now you have a controversy. The court's job is to deal with the controversy. Matthew 18, verse 15, 16, and 17 is usually the tool I use to answer these kind of questions. And if you go look at Matthew 18, verse 15, 16, and 17, read them from the perspective of a legal process. That's what the courts are actually going to follow. Believe it or not, they actually follow this. It's called the administrative process today, but in reality, it comes from there. That's the source document. And it says if two parties are in a disagreement, you come together and you work it out. If then 16 is, well, if they can't agree, then you bring a witness, and that could be arbitration, an attorney, just somebody that can look it over and say, yeah, you're right. This is what it says. Now I agree. Let's go ahead and do it as the contract says. 17 says if they will not agree, then you take them to the judge, and they say the priest in some versions of this, and you treat them as you would a tax collector. In other words, you go after them, you fight it.
Mm-hmm.
That's what those three verses mean. They actually are the strategy to conflict resolution. This is still a conflict resolution, even though you kind of agree. But now the state's got to agree because the estate is the state's property unless it's resolved through a private contract. That's why good trusts are so powerful. That's why we want everybody to be learning how to do trusts or a trust program. It helps you with so many things. Daniel, go ahead.
A right solely enforceable in equity.
Yep.
Trust.
And equity is the agreement. That's all it is.
And Karen, your who was it? Your mother?
No, it was my sister who died.
Okay, your sister left everything in your daughter's name for a reason.
Yeah, except for $100,000 to me, $100,000 to my other sister, and then the 25 to SPCA and another animal rights organization, another 25,000 to them. Oh, and 25,000 to her housekeeper.
Beautiful, beautiful. She was a really
Wow, they're a housekeeper. That's nice.
We were afraid
my house that good.
we were afraid she was going to leave everything to her housekeeper until we found the trust.
Wow. That's one good housekeeper. I wish I had one of those.
Oh, no, not this one. Okay. Well, thank you very much.
Okay, no problem. All right, we have another caller, looks like Catherine.
Hey, TJ.
How you doing?
Pretty good. How about you?
Yeah, good.
Good. I just wanted to let you know you may remember or not, more than a year ago, I started using the delete debt process on a debt collector that I actually did have a written contract with. It was a home improvement loan. I can't go into a ton of detail because the settlement, but I wanted to let you know that the first iteration of the letters, and I've seen they've changed, right, since since you first started.
Yeah, they've evolved a bit.
There was one sentence in there that essentially clinched the case. I decided not to go the route of small claims with this particular one because there were too many statutory damages that put it in the realm of like 5 figures statutory
Hmm.
damages. So I initially filed it in state court and then they pushed it into federal court. And
Oh, really?
yeah, and the thing that clinched it really was the statement of "do not contact me." There and
And they
it doesn't
did.
and it
Okay.
doesn't even say that in the letter. It's very vague, honestly. Um, so they actually wrote me back and acknowledged it and said, "We understand your client." I remember, I don't know if you remember, a long time ago I read you the letter, and their misunderstanding was that I was represented, which under the FCR, the
The Credit
FDRC,
Reporting Act. Yep.
they once they know you're represented by counsel, they actually have to stop contacting you.
Hmm.
So they acknowledged your client doesn't want to be contacted. We won't contact you anymore. And they did that 3 times. I sent 3 letters. Each response
$1,000 a pop.
was we won't contact you. And so then they proceeded to call me 47 times. Um,
Oh, well,
Acknowledging
that's
the
$1,000 a
revocation of
pop.
six. That's 500,
Don't
but
contact me.
it's
Yeah.
1,500 willful. So once you've revoked consent, then they sent out somebody to my door to leave a notice.
Wow. Okay.
And
They like writing checks.
they called me on Christmas Eve, which are all violations of the code.
Yep.
So
Right off that chart we give you.
so it was an interesting process. I had help, I will say, but it was really difficult. I mean, litigating in federal court, very hard, and I'm not going to
Hmm.
sugarcoat it to anyone. It was really hard, but the attorney acknowledged right off the bat, asked me to settle right away.
Yeah, he did. He has to.
Right, and this was even before the motion to dismiss.
How
So
much did you collect?
I got 37,500.
Well, that's not a bad
And if
few
you could
phone
edit
calls.
this out of your call, that would be great. Um,
Well, I don't know. I don't have, I mean, they don't know who it is. It really doesn't matter.
yeah. So yeah, no, it was about, I would say I started in February of 2025, and we tried to get it clawed back to state court. They brought it there. We tried to remand it because we wanted our whole goal was to get depositions scheduled like
Hmm.
right away, because as soon as the depositions were finalized, the price tag went up because now they knew that I had the ability to spank them pretty hard, and they did not want to be deposed at all. And I will say, and I want you to look into this because I think you're going to find this service extremely awesome. It's a service called FileVine, and FileVine actually works with pro se litigants. It's a deposition court reporter, certified in the courts, and they don't discriminate against pro se litigants, which a lot of services will. Like
Hmm.
I finally found a court reporter that will work with me, but it was difficult.
Yeah,
Um,
they make it a little sticky.
and this particular service will take your documents, take your case law, get your goals from the question it's an AI assisted deposition service, to put it in short form. And it will track your questioning, and it will give you the transcript real time, and it will tell you if you're on or off track in terms of your lines of questioning. It's a closed circuit AI, so it's not considered, what do they call AI?
Open or
Open
just yeah,
source.
yeah,
Yeah,
open source,
it's
large
closed
language
source.
model type stuff. Yeah.
Exactly. It's closed source AI, so it's not considered disclosing anything to a third party. It's specific to FileVine. And the FileVine people are super nice. They don't make you pay for the depositions up front. And you can schedule them. So I think in essence, it wasn't until I scheduled those depositions and he got noticed that he really, I mean, he was asking me to settle, but it really got serious after that.
Mhm.
And the
Yeah.
tangoing with the attorney was really the hardest, like going
Well,
back and forth with him.
yeah, yeah. And this is where also we recommend a lot of people, along with our courses, also get the How to Win in Court Without a Lawyer course. I don't know if you pulled some of that information from there, but it talks a lot about interrogatories, depositions, where you start pulling these people out on these kind of things, you're calling them out. They got to tell the truth. This is before court. You're on the offense at that point. You're controlling. Like I said earlier, he was asking the question, is the king. So by going in and taking this approach, okay, well, fine. You want to go to court? I have some interrogatories for you, and you ask them a bunch of questions. And then you have a discovery request, and then you move to a deposition to actually sit them down, make them swear under oath. Okay, where's your record of you ever lending me money? Or where's your record that you didn't do this? Or, if you did violate this, who's the person that did it? And they just don't want to go there because they know you're on the truth.
They
And
really tried to avoid discovery, and
yeah,
what the two
and you can do a
key
motion to compel discovery if they do. That's
the
the
two, the
follow.
two key moves were immediately, as soon as I was able, once we got past the motion to dismiss, we won on 4 counts. I went right
Beautiful.
to give me scheduled depositions. I sent notices of depositions, and he drug his feet. Well, the attorney that I was initially dealing with mysteriously left the firm after I beat him, and then basically
You let
drug
it go
his
too
feet.
far. You should have settled it earlier. You embarrassed him.
He could not win. He couldn't. Not only could he not win the motion to dismiss, he ended up losing his objection to one of the adopted. The magistrate gave the presiding judge her recommendations. He objected to it. I responded, and the presiding judge says, and we agree with plaintiff. I
Oh,
mean, she
geez.
said objection is overruled because of what plaintiff said, basically. Like
Yep.
in so many words, what plaintiff said. So it was basically after that he dropped off the case, and then
Yeah.
they
And
moved
you,
me in to
you'd be
deal with
surprised how
her.
many times when people really start pushing and doing the right things, setting them up, they realize that, you're not a low-hanging fruit. And that's where the fraud gets discovered. All these people, listen, people say all that, their attorney said this, their attorney said that. Well, if that attorney is representing somebody who committed fraud against you, why would they change all of a sudden? They're going to lie to you. As I always say, it's kind of like the New York lawyer. The
Yeah.
lawyer is it lawyer, is a liar, lawyer. Which one is it? You know what I mean? And if you use that language, you start saying, well, gee, a lawyer sounds a lot like liar. And I'm not trying to be offensive to my lawyer friends because they will actually agree anyway, that I'm simply pointing out the truth about what they will do. They're going to testify. And you don't realize they're testifying. You have to say, objection, Your Honor. He's not a witness. He cannot testify. Can't come here and say X, Y, and Z happened, which they do
Yeah.
all the time. And if you allow it, then it sticks in the record. If you disallow it, you object, you put yourself in the position to force them to actually start proving something real.
Well,
You don't buy the lie.
what I discovered about that is that there really wasn't opportunity necessarily for that, because when we got in front of the judge, it was informal discovery conferences where
Yeah.
he wouldn't produce the deposition date. So I had to really push him, push. I want it by this day. When he didn't do it, I said, okay, now we're going to go to an IDC. Here's my end of the joint statement. And I requested through the clerk. I followed the judge's standing orders, requested it through the clerk, went to the hearing, and the judge was like, um, why are you not giving deposition dates? And he's like, well, Your Honor, we want to get a protective order. Well, you can't have a protective order until you motion for it. And I'm going to tell you right now, if you want a blanket protective order, you're not going to get it. She's entitled to discovery. She's entitled to know who made the calls, and he got severely spanked in that hearing. And so from there on, he just kept losing essentially. And at one point he was begging me not to go to the depositions. And that's where I think it was able to come in at the higher number than they counter offered at 4 and
Yeah.
ended at 37.
Is
So
that the best you can do? Because I don't know. The fly on the ceiling says, that's probably not good enough.
No, I was like, are you kidding me? No, your statutory damages alone are 85. So
Yeah.
I'm not settling
And
at
federal
4.
law states what all these violations add up to. That's why I give people that chart. Like there's money on the table when they start doing this stuff. The reason the chart exists is because they do it a lot. You just got to catch them.
Yep. Yeah, it was
Beautiful
pretty
job.
amazing. Hard
Good
work,
job. Good for you.
totally
You're a
worth it.
hero of UR Law for doing that. Really.
Uh, Thank you.
No,
Anyway,
absolutely.
thanks
Because
for
like
your
I
guidance.
said, I learn more from the real world stories than I ever teach.
Yeah, it's really rare to get into these situations. I mean, I'd never imagined myself in federal court. But I used Perplexity and I did have help. I have a crew of people that I work with. So
Ah,
I
okay.
definitely did not do it by myself, and these folks are their credit consumer law veterans. So I
Mhm.
had
But
help.
ultimately, they're doing what we're teaching. It does sometimes require the extra help, and that's fine.
It really, yeah, to
But
go
it's
to
the
federal
same
court.
principle.
Yeah. All right. Well, that
Okay.
was my
Well, thank
story.
you very
Thank
much. It's a
you.
great story. I really
Yeah.
appreciate that. That's awesome. Good news.
Yeah. Thank you.
All right. Take care. Ladies and gentlemen, we are over time and out of time. But I appreciate everybody being here. This was a really good call. I think that last story should give you a lot of encouragement that you can do these things. She used some extra leverage and tools. That's fine. Actually, the next generation of the website that we're working on is going to have additional tools like that available. We just haven't finished it. It's actually in the works. I literally was on meetings about it this afternoon. So when it's ready, because it's not simple, we of course put those out there. You don't need to rush to that. People are doing a good job for the years as we are, but we are always trying to improve things. So don't ask me a question. When's it going to be done? Because I don't know. It's done when it's running, we've tested it and everything works. So I never try to put expectations of deadlines out there, except I can tell you it's actively going on and programmers are working on it. And it's going to be an improved version of the website. It's going to actually offer some different types of memberships soon to cover the additional tools and resources we're putting out there. So stay tuned. You'll be hearing about it. Danny, do you have any concluding words?
No, just that, let's stick together. There's only way we're gonna get places is together.
Yeah,
I
that's right.
know my mom was a Jewish attorney. I see how that community operates, and I'm like, wow,
Yeah,
that's amazing how 2 people can take 10 people can take $1 million and trust each other with it. Wow.
yeah.
It's, I look at them and I'm like, man, us Christians we need to
Gotta
start.
stick together. We're a little club, we are, and that's why we try to formalize things in different levels of membership so people are working on the same content, same creativity together. I will ask anybody, but Daniel's, put some information out there. Um, Keep in mind, he'll be sure you let him know that you're at least a premium member of the UR Law site. That's who we allow to come through and talk. Just so he also knows, because we may have arrangements for referring people back and forth. So make sure he knows that. And otherwise, I'm going to take it. We'll go for now. You'll be hearing more as we're evolving. A lot's going on. I'm getting called out to do a lot of public appearances now, and I think we're going to get big increase in membership soon, especially once our affiliate system is kicking in. Watch for news. It'll happen when it happens, when we announce it, not before. So keep that in mind. Anyway, you guys know how to reach us if you need anything, and we'll be catching you all soon.
Have a good night. God bless you.
Thanks, guys.
You bet.
Welcome, bro.